ಅಷ್ಟೊಂದು ಪ್ರಮಾಣದ ಚಿನ್ನ ನಿಮ್ಮನ್ನಲ್ಲಿ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ? ನೀವೆಲ್ಲ ಗೂರ್ಖ ಅಲ್ಲಿಂದ ಬಂದು ಮನೆ ಕಾಯಿರೋ ಅಂತಂದ್ರೆ ಮನೆಯನ್ನ ಖಾಲಿ ಮಾಡಕ್ ಬಿಟ್ಟಿದ್ದೀರಿ. ದೀಸ್ ಪೀಪಲ್ ಡೋಂಟ್ ಡಿಸರ್ವ್ ಎನಿ ಮರ್ಸಿ ಫ್ರಮ್ ದಿಸ್ ಕೋರ್ಟ್. ಅಲ್ಲಿಂದನೂ ಅನ್ನ ತಿನ್ನಕ್ ಬಂದು ನಮ್ಮನೆ ಅನ್ನ ಹಾಕ್ತಾರೆ ಅಂದ್ರೆ ವಕೀಲ್ರೆ ಬಹಳ ಕಷ್ಟ. ನಾವು ಅದನ್ನ ಗಮನದಲ್ಲಿ ಇಟ್ಕೋಬೇಕು, ತಪ್ಪು ತಿಳಿಬೇಡಿ. ನಾವು ಒಬ್ಬರನ್ನ ನಂಬಿ ಮನೆಯಲ್ಲಿ ಬಿಟ್ಕೊಳ್ತೀವಿ, ಅದು ಅವರು ಅದೆಲ್ಲ ಫಾರ್ಮ್ ಹೌಸ್ ಅಲ್ಲಿ 10 ದಿವಸ ಇಟ್ಟು ಆಮೇಲಿಂದ ಮನೆಗೆ ಸೇರಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಸಬಿತ್. ದಿ ಕ್ರೈಮ್ ಸ್ಟಾರ್ಟೆಡ್ ಮಚ್ ಅರ್ಲಿಯರ್, ನಾಟ್ ಆನ್ 31/12. ಎಲ್ಲ ಪ್ರೀ ಪ್ಲಾನ್ಡ್. ಮನೇಲಿ ಎಷ್ಟಿದೆ ದುಡ್ಡು ನೋಡ್ಕೊಂಡು ಅವ್ರದ್ದು ಮನೆಯವ್ರದ್ದೆಲ್ಲಾರ್ದು ಪ್ರೀತಿ ವಿಶ್ವಾಸನ ಗಳಿಸಿ 1140 ಗ್ರಾಮ್ ಗೋಲ್ಡ್ ಒಬ್ಬರ ಮನೆಯಲ್ಲಿ ಸಿಗುತ್ತೆ ಅಂತಂದ್ರೆ ಪೊಲೀಸ್ನವರು 1140 ಗ್ರಾಮ್ನ ಇಂಪ್ಲಾಂಟ್ ಮಾಡಿ ನಿಮ್ 4 ಜನನ ಸಿಕ್ಕಾಕ್ಸಲ್ಲ. 10 ಗ್ರಾಮು 20 ಗ್ರಾಮು ಓಕೆ, 1140 ಗ್ರಾಮ್ ಪಂಚನಾಮೆ ಇದೆ, ಫೋಟೋ ಇದೆ, ತಾವಿದೆ, ಅವ್ರ ಮನೆಯಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ರಿ, ಫೋಟೋ ಇದೆ. ಪ್ಲಾಸ್ಟಿಕ್ ಗ್ಯಾಸ್ ಸಿಲಿಂಡರ್ ಪಕ್ಕ ಅಂತ ಟ್ರಯಲ್ಗೆ ಇಟ್ಕೊಳ್ಳಿ. ಅವೆಲ್ಲ ಇನ್ನೋಸೆಂಟ್ ಅಲ್ಲ, ಅವ್ರು ಇನ್ನೋಸೆಂಟ್ ಆಗಿದ್ದಿದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡೋದು. ಇನ್ನೋಸೆಂಟ್ ಅಲ್ಲ, ದೂರದ ದೇಶದಿಂದ ಬಂದು ಊಟಕ್ಕೆ ಅಂತ ಬಂದು ಕನ್ನ ಹಾಕೋದು ಸರಿ ಹೋಗೋದಲ್ಲ. ಬಟ್ ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ದಟ್ ಈಸ್ ಕಾಲ್ಡ್ ನೆಗೆಟಿವ್ ಪ್ಯಾರಿಟಿ ಅಂತ, ನೆಗೆಟಿವ್ ಈಕ್ವಾಲಿಟಿ. ಆ ಬಿಲ್ಡಿಂಗು ಅಕ್ರಮವಾಗಿ ಕಟ್ಟಿದ್ದಾನೆ, ಅದಕ್ಕೆ ನಾನು ಕಟ್ತೀನಿ, ನನ್ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೋಬೇಡಿ, ಅವನ್ ಮೊದ್ಲು ಹೊಡೆದಾಕ್ಬಿಟ್ಟು ನನ್ನ ಹತ್ರ ಬನ್ನಿ ಅಂತ ನೀವು ಕೇಳಕ್ ಆಗಲ್ಲ ಕಾನೂನಲ್ಲಿ. ಅಷ್ಟೇ, ದಟ್ ಇಸ್ ದಿ ಪಾಯಿಂಟ್. ವಕೀಲ್ರೆ, ದಟ್ಸ್ ವೈ ಐ ಆಸ್ಕ್ ಯು ಒನ್ ಕ್ವಶನ್, ಡು ಯು ಕ್ಲೈಮ್ ಓನರ್ಶಿಪ್ ಓವರ್ ದಟ್? ಇಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ಮಲ್ಲೂ ಇತ್ತು ಬೇಕಾದಷ್ಟು, ನಾವು ಆಗರ್ಭ ಶ್ರೀಮಂತರು, 1 kg ಚಿನ್ನ ನಮ್ಮಲ್ಲಿ ಇರೋದೇನ್ ಮಹಾನ್ ಇದು, ನಮ್ಮಲ್ಲಿ ಚಿನ್ನದ ಸಿಂಹಾಸನೇ ಇದೆ ಅಂತ ನೀವ್ ಹೇಳಿದ್ದಿದ್ರೆ ಆವತ್ತಿನ ದಿವಸ ಒಪ್ಕೋಬಹುದು. ಹೂ ಆರ್ ಯು? ವಾಟ್ ಈಸ್ ಯುವರ್ ಅವೊಕೇಶನ್? ಹೂ ಆರ್ ಯು? ವಾಟ್ ಈಸ್ ಯುವರ್ ಅವೊಕೇಶನ್? ನಿಮ್ಮ ಹತ್ರ ಹೆಂಗ್ ಬಂತು ಮತ್ತೆ ಅದು? ದಟ್ ಈಸ್ ಅಲ್ಲ, ನೀವ್ ಹೇಳ್ಬೇಕು. ಅವನ್ ಕದ್ದವನು ನಿಮ್ಮನೇಲಿ ತಗೊಂಬಂದಿಟ್ನಾ? ಅದಕ್ಕೇನೆ ಟ್ರಯಲ್ಗೆ ಆಗ್ಲಿ ಬಿಡಿ. ಕಳ್ಳನ್ಗೆಲ್ಲ ಏನ್ ಕೊಡೋದು ಬೇಲು? ಸ್ಟೋಲನ್ ಪ್ರಾಪರ್ಟಿ ರಿಕವರ್ಡ್ ಫ್ರಮ್ ಯುವರ್ ಹೌಸ್ on the basis of the voluntary statement given by you, and when you don't claim the ownership over those articles, offense is complete. Or standing outside the house only to give you the signal if somebody comes from there. ಆಯ್ತು, 2 ಸಿಗ್ನಲ್, ನೀವ್ ಯಾರು ಬಂದ್ರೆ ಅವ್ರನ್ನ ಅಲ್ಲೇನೆ ಹೊಡೆದು ಮುಗ್ಸಕ್ಕೆ. ಸರಿ, ನೀವು ಹಾಗಾದ್ರೆ ಸುಮ್ನೆ ಬೀದಿನಲ್ಲಿ ನಿಂತಿರೋರಾದ್ರೆ ನಿಮ್ಗೆ ಯಾಕೆ 1000 ಗ್ರಾಮ್ ಚಿನ್ನ ಕೊಟ್ಟ, 1 kg ಚಿನ್ನ ಕೊಟ್ಟ ಅವನು? ನಿಮ್ ಮನೆಯಲ್ಲಿ ಏನ್ ಸಿಕ್ತು ಅದ್ ಹೇಳಿ. 1 kg ಚಿನ್ನ ಸಿಕ್ಕಿದೆ, ಅಲ್ಲಿಂದ ಬಂದು ಊಟ ಮಾಡ್ರು ಅಂತಂದ್ರೆ ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಕಣ್ಕಂಡವ್ರ ಮನೆನೆಲ್ಲ ದೋಚ್ತೀರಿ. ಯು ಆರ್ ಫ್ರಮ್ ನೇಪಾಳ್. ಇಫ್ ವಿ ಗ್ರಾಂಟ್ bail, you will not be available for the trial. Yes, upon the complaint lodged by Ranjini Rajkumar, wife of Rajkumar, Banashankari police have registered a case in crime number 203/2021 for the offence punishable under section 381 of the IPC on 31/8/2021. In the complaint, it is contended that the complainant is resident of a house bearing number 1 Ashwatha Layout, 6th Cross, JP Nagar, 7th Phase, Puttenhalli, Bangalore. Posta. She had visited her mother's house, and when she returned to the house, the maid servant by name Sabita was missing. Posta. On verification of the CCTV footage, she has noticed that Sabita had allowed 2 unknown persons to break through the bedroom in the house and stolen away jewelry worth 4 crores and between 12:47 a.m. to 3:55 a.m. on 31/8/2021. Posta. Sabita was introduced by Kamal, who has been employed with them. Posta. There has been no tampering of the locks. Posta. Based on the said complaint, Police registered the case as above and investigated the matter. During such investigation, petitioners herein for accused number 4, 5 and 6 were apprehended by the police and inquired. First, they have given the voluntary statement, and based on the voluntary statement, the investigation agency is able to recover gold ornaments weighing 1140 grams. 1140 grams from the house of the second petitioner, who is the fifth accused. First, next para. Voluntary statement of first petitioner, accused number 4, and third petitioner, Saubhagya alias Sunita, accused number 7, clearly show that the gold ornament recovered from the house of the accused number 5, Mithun, was the gold ornaments which are the subject matter of the theft. First, next para. Subsequently, the accused persons were produced before the jurisdictional magistrate and they are remanded to custody. First, next para. The attempt made by the petitioners herein to seek for grant of bail is turned down by the learned district judge in CMIS number 11,217 of 2021 by order dated 22nd December 2021. First, next para. Thereafter, petitioners are before this court. First, client counsel for the petitioner, Shri so and so vehemently contended, Shri Pradeep Patil vehemently contended that petitioners are innocent of the offences alleged against them and therefore they are entitled for grant of bail. First, next para. He also contended charge sheet is now filed and co-accused by name Kamal Shahi alias Kalu has been enlarged on bail by this court by order dated 1st February 2022 in criminal petition number 535 of 2022, and therefore on the ground of parity the present petitioners are also entitled to be enlarged on bail. First, next para. Per contra, Laird HCGP opposes the bail petition, stating that petitioners are all residents of Nepal, and once they are enlarged on bail, there is every possibility that they would flee away from the trial, and therefore, sought for rejection of the bail. First, he also pointed out that the present petitioners do not stand on the same footing that of the persons who have that of co-accused Kamal Shahi, who has been granted bail, inasmuch as the role assigned to the present petitioners and Kamal Shahi are altogether different. First, and sought for rejection of the bail. First, in view of the rival contentions, this court perused the material on record meticulously. First, next para. Admittedly, there are voluntary statements of these petitioners after their arrest. First, pursuant to the voluntary statement given by these petitioners, the investigation agency is able to recover 1,140 grams of gold from the house of second petitioner, accused number 5. First, next para. Admittedly, the petitioners are working as petitioner number 1 is working as a security personnel. Petitioner number 1 and 2 are working as security personnel, and petitioner number 3 is working as a maid servant. First, possession of 1,140 grams gold in the house of accused number 5 is unexplained by accused number 5. First, voluntary statement given by the accused persons and subsequent recovery and discovery of the gold ornaments, resulting in the discovery of the fact of alleged theft by the investigation agency is a matter that cannot be lost sight of by this court while entertaining the request made by the petitioner for grant of bail. First, next para. Prima facie materials on record, especially the recovery of 1140 grams of gold from the custody of the second petitioner, accused number 5, at the instance of the voluntary statement given by all the petitioners, is a factor, is a relevant factor, and receiver recovery of the stolen property in a matter of this nature assumes a great importance. First, next para. Further, comma, the ground of parity is also not available for the petitioners in as much as there is no voluntary statement given by the accused Kamal Shahi, and pursuant to that, there is no recovery. First, as could be seen from the complaint governments, as could be seen from the voluntary statement, Kamal Shahi was standing outside watching for any public movement so as to caution the persons inside the house, First, this court, while granting the bail, has taken note of the said fact and has enlarged the Kamal Shahi on bail. First, but the voluntary statement of these petitioners and pursuant to the same recovery of 1140 grams of gold would be a relevant factor while considering the case of the petitioners on parity. First, therefore, this court is of the considered opinion that the material on record, insofar as these petitioners are not sufficient enough to hold that they are in parity with the Kamal Shahi who has been granted by this court. Accordingly, this court is of the considered opinion. Further, all the petitioners are permanent residents of Nepal, whereas Kamal Shahi is the resident of Karnataka. First, if taking note of these facts, this court is of the considered opinion. That if the petitioners are enlarged on bail, there is every possibility of they fleeing away from the trial. Accordingly, this court is of the considered opinion that no grounds are made out for grant of bail by resorting to the special powers vested in this court under section 439 CRPC. First, however, since the accused persons are in custody, the trial needs to be expedited. Accordingly, following order is passed, bail petition rejected. Having regard to the fact that the accused petitioner, including the petitioner number 3 being the lady, the trial court is directed to expedite the trial and conclude the same on or before 31/3, 31/12,